Today on Out of Network, we're joined by Adam Garth, an accomplished healthcare defense attorney with more than 3 decades of experience representing physicians, hospitals, and medical organizations in some complex medical malpractice and liability cases across this country. A graduate of Tufts University and Syracuse University College of Law, Adam is a partner at Gordon, Reese, Scully, Manzicani in its Las Vegas and Reno offices, part of the first law firm to establish a presence in all 50 states. Known for his aggressive and meticulous defense strategy, Adam focuses on early case resolution while holding plaintiffs to every legal standard required. Adam is a seasoned trial lawyer who routinely represents clinicians before licensing and administrative boards throughout Nevada, and he advises physicians on employment contracts, professional corporation formation, making him uniquely positioned to discuss the legal pressures facing doctors today and how they can protect themselves in an increasingly complex healthcare environment. Good morning, Adam. How are you? Welcome to Out of Network.
Thank you. It's a pleasure to be here.
Is this the first time being on a podcast?
It is.
So I don't think there's a lot of lawyers being asked to be on a physician podcast. Would you agree with me?
I would say that's true.
So should I be afraid or should you be afraid?
Probably I'm the one who's going to be a little bit more afraid, but
well,
that's
welcome.
Okay.
Welcome. I'm going to start with, what is it like to be an attorney in Las Vegas, Nevada?
Well, to do litigation, it is a challenge. There are a tremendous number of plaintiff attorneys here in town. There's a lot of competition for business.
Mm-hmm.
I am on the defense side. The plaintiff's bar is a very organized group of people. The judges here, for the most part, have not done a lot of civil litigation. So their experience level is not that high when it comes to medical malpractice cases. Most of the time they come from the public defender's office or the district attorney's office, and they've got a criminal law background, but they don't have that civil law background that you would need to know this kind of stuff. And the rules can be somewhat complicated. The concepts are incredibly complicated. You're dealing with science, you're dealing with law, and merging the two is a challenge.
Challenging. And I've heard, is this true that there are more lawyers in Las Vegas than physicians?
Probably there are. There's been, and there's an increasingly fewer number of physicians as they leave the jurisdiction because it is not really a defense-geared jurisdiction.
Sure.
A lot of the physicians sort of feel, for lack of a better term, under assault.
Sure.
And as a result, they're fleeing they're fleeing Las Vegas faster than we can bring them in.
Right.
And
why is that? Is it because there's an unlimited? There's sometimes a cap on malpractice, and sometimes there's not. So is that influencing why physicians are not staying in Nevada?
Well, there is a cap on what would be known out in the world as pain and suffering damages, but there isn't a cap on what are known as economic damages. Those would be lost wages, hospital bills, any actual dollars that you've expended, and the problem is that more often than not, some healthcare organization or a physician is brought into a lawsuit simply to cover the bases. There may not be a lot necessarily known in the beginning of a case, but there are fewer times that physicians or healthcare organizations will be let out of a case. As a result, they're in it for what could be 2 or 3 years with this cloud hanging over their heads. That increases malpractice premiums.
Of course.
And it becomes, from a business standpoint, very difficult to remain here with lower insurance reimbursements, higher malpractice
which
costs.
we always talk about here on this show.
Correct.
So
it's become a significant challenge, and recruiting and keeping good physicians in town has become more difficult in that kind of an environment.
So from a legal perspective, what would need to change to make Nevada a place to come and practice medicine?
Well, you probably need caps on all of the damages. That's probably not going to happen. Some of the political leaders in town happen to be plaintiffs' lawyers, so they're not going to be changing things that would be economically disadvantageous. If we get a better crop of healthcare practitioners, that would probably tamp down the number of lawsuits. But the really good ones don't want to stay.
Let's jump off that for a second. So do you think because of the current legal situation or legal standards, does Nevada attract unqualified doctors?
I think that having seen the medical education evolve, I think people are less prepared.
Sure.
And that's more on a national level. That's not necessarily restricted to Nevada.
Sure.
And as a result, you're going to not get the same quality of physician. But when really good physicians who are being unjustly brought into lawsuits or feel that they're under that kind of an assault and they don't want to stay here, they have other opportunities nationwide to go. Unfortunately, those who are not as qualified have fewer choices. As a result, they stay. So there tends to be more of a physician population that has some greater difficulty. But we are attracting people here for other economic reasons. But as that dichotomy winds up expanding between lower reimbursements, higher malpractice premiums, a doctor just can't make ends meet in a practice.
Right. And I think for the audience that has listened to my story, our story on the podcast, I've seen both sides of the spectrum. You know, when I first came to Las Vegas, working in a traditional practice, being almost not set up for success because of that you're just talking about. It is quite challenging practicing medicine in this state. And to be very blunt, it's the whole reason why I went the route of concierge medicine, because in a way, I can practice medicine the way I want to without necessarily fighting tooth and nail for insurance reimbursement that is already capped at a bare minimum. So, and it brings up a good question that I've always wanted to ask you. So practicing concierge medicine, does it, in your opinion, reduce malpractice risk, or is there some type of legal exposure that I'm not aware of?
Well, in most cases, it would probably reduce the malpractice risk, because concierge physicians by nature are going to limit the quantity of patients in their practice.
Right.
As a result, they can spend a lot more time, because they're not dependent upon insurance reimbursements to move patients through a normal day. So a typical concierge physician may see 8-10 patients in a day, where a typical general practitioner in a traditional practice may see 40 or 50 patients in a day.
Right.
And there is no way that a physician can possibly devote the time necessary to evaluate the patient completely. But unfortunately, due to economic circumstances, those in traditional practices have no choice in order to keep the lights on of seeing those number of patients. So from a sheer quantity standpoint, you're going to reduce your risk by being able to spend more time, gather an appropriate history.
Plus, to jump off of that, how can a physician remember to document well when they're seeing 40 to 50 people a day? And you and I just spoke how documentation is so critical from a legal standpoint, correct?
It is probably one of the most critical. When you go to medical school, you're learning the science, you're learning, how to be a doctor, but you're not learning defensive medicine. And doctors aren't taught how to be business people. And in being a business person, which you need to be in order to be a physician, you need to be able to protect yourself.
Right.
And the best way of doing that is keeping good, accurate notes.
Right.
But seeing 40 or 50 patients a day, number one, you're not going to have a lot to put in a note because you're not seeing the patient very long. But number two, there is no way going from patient to patient to patient that you are able to get your notes in a timely fashion.
Right.
You're going to forget something that you've done with that patient. And it's often said that if it doesn't appear in the chart, it didn't happen. Now, it may very well have happened, or it may not be a significant thing. But on that one case that winds up being called into question, if there is something missing from the chart, that's usually what the plaintiff's attorney is going to capitalize on.
So critical.
It is.
So one of the greatest advancements, I think, in medicine, at least for me, that we've talked about quite often on the show is the advantages of AI and the benefits of what AI can do for scribing and documentation. Do you see any problems as an attorney of how that could either help or truly hinder that physician using these services?
It's interesting you say that, because in many industries, including the legal industry, AI is coming into force, and we are going to need to use it to be competitive. But at the same time, it comes with its own risks. There have been documented cases of attorneys, for example, who utilize AI to create a legal brief that turns out the AI is quoting non-existent legal precedent to a court, and the attorneys have gotten into a lot of trouble. I suppose the controlled use of AI in medicine would be beneficial, because you can, say, dictate and things like Dragon Dictate and other kinds of products that people have used in the past. There are more sophisticated AI products now, but the doctors will need to check their notes.
They do.
And make sure that the transcriptions are accurate.
Right.
Otherwise, you're going to be, if you're relying exclusively on AI and you're not checking things out, you're opening yourself up to liability.
And as you know, we use AI in the practice, and it has been a game changer. But I think you know me well enough. I like to socialize a lot with my patients, and it's interesting. When I went back to look at the transcription on one patient, we were talking about a new movie that was coming out, and part of my recommendations for anxiety was, you need to watch this movie coming out. So delete.
Delete. But in a concierge practice, you're going to have that kind of time to do that editing.
Exactly.
But in a traditional practice, you're probably never going to see that note. You're going to enter it, close out the note, move on to the next patient.
And I have seen it so often, even working in the hospitals, when we're inundated with the volume of patients. And I'm not an attorney, but looking at these notes thinking, this was just copied over from the day before or the week before. What has changed?
I see it all the time. I not only represent physicians, but I represent large institutional healthcare organizations and hospitals throughout the Valley. And when we receive a patient chart, it's not in any one particular order, but then when you start ordering things chronologically, you see notes that are just essentially cut and paste.
Correct.
Or they auto-populate from the prior day, and there isn't a change that the practitioner is making to the note.
Right.
And that's a problem, because you're wondering, how is this patient's
because
condition
they're still
changing?
submitting it to an insurance company. So is it laziness, or is it the fact that the physician is just so inundated with the volume of patients that they're seeing that they truly don't have time?
I think it's a combination of things. I think, number one, it's the EMR, or electronic medical record program, and how it is utilized, right? There's that, and you have all your drop-down menus and so on that physicians have to use. There are very few areas where there's an opportunity for free flow of information to be inputted. Mostly there's clicking of different drop-down menus, buttons on screen that populate things.
Makes it easy, but
It does. Now, some physicians like to cut and paste a note from the prior day so that they have, on a daily basis, an easy way of looking through the chart, moving, then adding their notes from the current day. But all too often, those notes don't reflect what has been done that current day.
It's all balancing expectations, but having it in writing. And it's so important. All of our patients sign a contract when they join Parker Medical, and we really try and follow those standards with everyone. I know that there are some physicians that practice traditionally without a contract per se, a concierge contract. And then they also on the side have patients in a concierge practice. So when I started Parker Medical, I was informed that you either do 100% concierge or not at all, that there could be some legal issues if you do both. In other words, so is this patient who I'm paying so much money for getting better care? Do you see what I'm saying?
Yeah, I think you're running into a problem because if you're you have to decide what you want to be.
Correct.
All right. And I understand someone in the beginning may want to be able to get cash flow in to do that. But you are putting yourself at some kind of a risk, because if a person is paying a considerable amount of money, they're the consumer, they're the customer. And while we don't like to talk about that in the healthcare field, that is the practical business reality. And if someone is paying for something, they have a right to expect what they're paying for.
Right.
And if you have a traditional practice combined with a concierge practice, by its very nature, you're not going to be able to spend the same amount of time with the non-concierge.
Which goes to what you were just saying, balancing those expectations.
That's correct.
So I can see the challenges with that. So going back to documentation, do you think that is the single most common issue, mistake that gets physicians in trouble then?
I would say above all,
okay,
it is documentation. Physicians are judged based upon their clinical medical judgment, whether it was reasonable or not.
Okay.
And that's typically what is placed into what I mentioned before, which would be standard of care.
Okay.
But regardless of the judgments that you're making, if you are not explaining to someone what you were thinking, because chances are you would not be brought into any kind of a lawsuit for more than a year after you saw that patient. You will have seen thousands of patients in between. You're not going to remember exactly what you did. There may be a habit that you have, and you can testify during the case that this is my usual course of practice. This is what I do in each and every case, so I'm sure I did it in this case. However, if it's not in the chart, there will be a question of whether or not you did it.
So let's say we've documented well. Obviously, doctors are humans. We all make mistakes. Do you think it's a problem for me if I fess up to that and say, I'm sorry? Is there a problem? I guess trying to bring the humanistic side back to medicine. So many doctors, I feel, are afraid to approach that under the advice of counsel. But if I've done something wrong, that's the first thing I want to do is fess up to and say, I'm sorry.
Well, there are two answers to that question. One is the legal answer, and the other is the practical answer. So let's start off with the legal answer. Under the rules of evidence, any admissions that you make that are against your interest. So in this particular case, you say, hey, I messed something up. That can potentially be utilized against you in a legal case. However, on the practical side, more often than not, when physicians approach a patient or a patient's family and fess up, as you're saying, to what happened, more often than not, the family or the patient doesn't pursue legal action. So it becomes a double-edged sword. If they do pursue the legal action, it could be used against you. But that being said, chances are it's going to come out anyway.
Right.
So why not reduce your risk and fess up to it? If it turns out you are involved in some kind of a lawsuit, that's what you have malpractice insurance for.
Exactly.
And that's what you hire people like me to defend.
Regarding licensing board actions, what do you see as a common complaint? And is there a very specific complaint among MDs as opposed to mid-levels, nurse practitioners, PAs, for example?
Well, that's a multi-part question. So let's take the last part first, which is, let's say, physician extenders. We can sort of group them in as NPs, PAs, and so on. They have lobbying groups where they want to market themselves as being just as good as a physician. They don't have the same training as a physician has. They are given a lot of license, depending upon which state in which they're licensed, to perform the same types of services physicians can. They can prescribe medications. They can order testing, but many times they don't have the depth of medical background that a physician has. They don't have the training, the years and years and hours of not only just medical school, but post-medical school training in clinical operations. And as a result, they may tend to overprescribe or incorrectly prescribe or over-test. Absolutely. And insurance companies are trying to encourage the use of these provider extenders because they don't want to pay as much money. But what they wind up doing is paying a lot more money because of the over-testing, because they don't know exactly what they're looking for. And when they get the results, they don't know what to do with them. That's not to say that each person, you're not going to have exceptions, but if you're putting a physician next to a provider extender, it's apples and oranges. So they run into their own licensing board problems.
PAs are under the medical board.
PAs are with the nursing board. That's correct. And the PAs have to operate under a collaboration agreement with a physician, and that creates its own problems because now the physician is assuming some responsibility for the PA. The NPs are practicing on their own, and they're practicing not under the physician's license, but under their own license. Completely independent. The problems that I'm finding with licensing boards, well, let's step back for a second. So licensing board actions can evolve from several means. Under the laws in Nevada, there is an affirmative obligation of a physician or a DO to report any claim of malpractice. So if a physician or a provider has been served with a copy of a complaint, they are obligated, whether there's any truth to the lawsuit or not, to report it to the medical board. The medical board then starts conducting an investigation, usually sends some kind of correspondence to that physician to explain himself or herself about what happened in the case. And the medical board can come to a decision of whether or not they're going to not pursue any action or they are going to prosecute the action. That's one mechanism. The other are patient complaints. And patients complain to the medical board about a host of issues. It could be a completely valid issue. Most of the time, it's about a billing issue or about the fact that they weren't treated with what they considered enough respect in the medical practice by someone at the front desk, over which the physician would not even know about what happened. And we spend a lot of time explaining these nonsensical things to the board, and it wastes an enormous amount of time. And many physicians don't have coverage for that. So they're paying out of pocket for a lawyer to draft a comprehensive letter saying, okay, now we have to see the patient chart. We have to go through everything, create a chronology, have the physician sign off on that. It takes many hours to put it all together for the medical board. Now, in my practice, we've been very lucky. Any initial inquiries, we sort of have a specialty in dealing with this. We're very upfront with the medical board. The attorneys who work for the board are quite dependent and are reliant upon our representations, and we tend to get extraordinarily favorable results for our clients when they're in that kind of a situation. But then there are situations where there's been a problem, and we have to try to navigate that for the physician.
Sure. Are these legitimate concerns, or is it more of a patient got pissed off at a physician and just wants to make it more difficult for that?
There's a combination. I know of many physicians who have to sit and defend themselves against ridiculous complaints of patients being angry about something. Not anything to do with really the medical practice. More often than not, it's what insurance wouldn't pay. Or you're now being billed for what insurance didn't pay. And even though you sign a financial obligation policy in every medical practice, say, we're going to bill the insurance company on your behalf, but if they don't pay, you are the patient and you are obligated to pay for the services. All of a sudden, the insurance company pays less than or denies the claim, and then all of a sudden it becomes the physician's fault. Now they're complaining about that, having nothing whatsoever to do with the care,
right?
But it's now a customer service issue.
Right.
And that creates a lot of problems.
Absolutely. Are there any new legal risks emerging with this idea of telemedicine? Obviously, during COVID, the pandemic, a lot of physicians were utilizing telemedicine services, and even now, insurance has agreed to continue a lot of these services. So are there new legal risks that the physician should be aware of?
There are. When you're not putting hands on a patient, that can create problems in and of itself. And I have a number of cases where a doctor has seen a patient in office, but has also conducted a telemedicine interview with the patient. And the patient doesn't necessarily provide the best history. When you're not putting hands on the patient, you can't observe definitively what's going on.
Right.
And there may be things that are getting missed. And if the patient is a poor historian, you're going to be limited by what you can see on camera and what the patient is actually telling you.
I agree.
So that's going to be a risk.
You may or may not know that when I bill for a telemedicine service, and it could be the same E&M code as I use when a patient is in the office, I actually get reimbursed more for seeing them via telemedicine. Explain that, right?
I've stopped trying to explain what insurance companies do and what they reimburse.
What would you tell someone starting out interested in doing concierge medicine that they should be advised or be aware? Because I do feel that concierge medicine is truly on the rise. I do. I mean, I hear it all the time. I see it all the time. I see the competition in our own community with new physicians, moving away from traditional practice and going into concierge. So what would you tell that physician that's important to think about from a legal perspective?
Well, as we spoke about earlier, what you probably want to do is to set limits on your practice. You're going to have to decide how much you're going to charge and what it is you're going to need in order to live whatever lifestyle you want. But you're going to you need to add additional physicians to that practice if it's going to exceed what you feel you can handle.
Sure.
Right. It's all about, and we don't like to say it, but every profession is a business.
Right.
And, healthcare providers are providing a wonderful service, but they have bills to pay just like anybody else.
Right.
So you need to set appropriate expectations and set limits for yourself in terms of setting up an appropriate practice.
Yeah.
Good staff is also
Of course.
Superbly important.
And, if it's in the contract, you try and honor it as much as you can. So like you said, the 24/7 access, the same day appointments, I know I can get running a little behind on some things, but I certainly say we try our best. But yeah, so setting those expectations are incredible. Can you talk about a case that you were involved in that's either shocked you from what was done by that physician, or can you talk about anything?
Most of the cases that I really can't talk about, I was involved in a case where I did not I represented a doctor who had zero responsibility for what happened to the patient. I was lucky in that regard. One of my colleagues had the burden of representing the doctor who had all the responsibility in the case. And what wound up happening was that the doctor did not follow a medical plan, did not review the notes, did not review anything that the prior physicians in the case were prescribing and recommending for the patient. Didn't even look at the chart, just cut and paste things from prior days, not really even examining the patient. And the patient died. There was a serious infection. It wasn't being addressed appropriately. And the doctor wound up losing his license as a result of the care or lack thereof in the case. So that was a pretty tragic set of circumstances. We have certain things where it's circumstantial. Just because you have a bad result, it doesn't mean someone did something wrong. It means sometimes there's a bad result. And I've had cases like that where the doctor has done everything. There is a failure of a medical device of some kind. The patient suffers an injury, but the doctor is blamed. Essentially, from what I found, at least practicing here as opposed to other jurisdictions that I've practiced in, is that the lawyers tend to go for the low-hanging fruit. Whoever is the most expedient to pursue. They won't necessarily look to pursue a products liability case because that is very expensive, very complicated to pursue. So now it's the doctor's fault as opposed to an equipment failure. Right. So that's there have been some tragic circumstances, and then there are things. Well, stuff happens, and the doctor isn't at fault. One case I'm involved in right now, I can't really talk about a lot of details in that case. The physician has zero responsibility. And it's what we refer to as a timeline case, where the doctor is being accused of not having done something in a timely manner, but it was temporally and medically impossible for the doctor to have done anything because the doctor didn't receive the testing information until after the damage to the patient had already occurred. And the medical records bear it out. The testimony of the plaintiff bears it out. But unfortunately, the plaintiff's lawyer doesn't want to let the doctor out of the case, even though they have no case to pursue, hoping to leverage a lengthy case to get some kind of a settlement. And they're not going to get anything.
Yeah, interesting.
And unfortunately, what's going to happen, and the way things work in Nevada, is if you issue a certain legal document to a lawyer and you offer to resolve the case under certain terms, if the patient, if the client chooses not to take that offer, and the result is that you get less in the end than the offer that was provided, you may owe costs and attorney's fees dated back to the date of that offer.
Wow.
And I'm very expensive. So an attorney, a plaintiff may wind up with a upper six-figure judgment against them because their lawyer did not let that particular healthcare provider out of the case.
Interesting. Wow. Well, I know you see and hear a lot of cases, and certainly on my end as a physician, seeing some cases. And I think I had shared with you a story of a female who went in for a routine OBGYN visit, waited for 3 hours, finally got brought back into the room. The medical assistant helped her into position for a pap smear, explained to the patient that the physician was going to be in right away. Well, she ended up falling asleep, woke up because her hip was on fire from being in that position, moves off of the bed, opens the door, and the lights were off. So this office in this community left her. And I'm not an attorney, but I told her, you know what I would have done? I would have stayed there as uncomfortable as I would have been, slept overnight. And when that physician and administrator came in the next day, I said, you better have some explaining to do.
And that
is negligent.
It's extremely negligent. I guess the question, there's negligence in the legal sense, and then there's just, it's not okay in the human sense.
And what was the breakdown there?
Well, this is probably what we were talking about before, is it's basically a McDonald's type practice. And that's what patients have now come to expect of their doctors. Right. It's like, hi, welcome to McDonald's. Can I take your order, please?
Right. Next.
And next, you want, they walk in and they tell you what you're going to prescribe for them. Yeah. There's that kind of a mentality because you're bringing them in, bringing them out, and I'm sure they lost track of the patient. Yeah. There's no excuse for it, but that is probably the reality of what happened.
And I don't want to judge, but you see an office that is geared towards speed and profit over presence and purpose. And that's what I feel like the concierge doctor is winning at, because it is not a McDonald's type of setting. Patients are getting better care. They're being listened to. It is not this rush in, rush out.
Well, and that's more of what, when I was younger, what medical practices tended to be. Sure. I think there was a major shift in probably the early to mid 90s when HMOs became all the rage, because it was just so much cheaper than traditional indemnity insurance. And doctors had to get onto these HMO plans in order to be able to keep their practices open. And that's when the reimbursements started to really go down. Sure. And we began to develop this fast food type of medicine that we're now facing, and people are suffering for it.
What do you think is going to happen in the next 10 years with medicine? Obviously, your wife is a physician. You are, truly intimately involved in the healthcare field. What do you predict going to happen? And does it scare you? Does it?
It really does. I think, and it's not just in medicine. I see it in most professions and in most jobs. The rigors that's necessary for really performing any job well are not being enforced. Mm-hmm. Medical students, a lot less prepared than they used to be. They're coddled. I know of people who are teaching medical school classes where if it doesn't show up on the slide for some PowerPoint presentation, then they feel they don't need to be obligated to understand. Now, I don't know how many patients in a hospital setting are going to have a PowerPoint presentation that's going to be there. What are you going to do when you're facing the patient and you have to think on your own? And I think what is happening in healthcare, just like many other professions, is that people are not thinking.
Right.
They're not being taught how to think. I see it in the local schools. They're not being taught how to think. They are being passed along.
Sure.
And medical school, colleges, they are an industry. And when students aren't appropriately prepared and they are not forced to go through the rigors of what's necessary to be in that profession, they're not going to be good when they get out.
Your business just multiplied.
It's an annuity for me. I probably won't be around when the problems really arise, but there are going to be significant problems. I am concerned.
I agree.
For me and for my wife about what we're facing, but more importantly, what our children are going to be facing down the road, because they're the ones that are going to be inheriting these less prepared individuals.
So I graduated from residency 12, 13 years ago, And when I was a senior resident was when they changed the work hours. So I was part of that old school mentality of you work hard, you focus on the patient. We don't care if you sleep, but the patient care comes first. I mean, I can see both sides, but I can definitely tell with this change in preparedness policies, are they seeing enough patients that they need to be qualified? I mean, I would hope so, but I can tell even working in a graduate medical education program currently, I can see the difference even in the last 10 years.
Well, my wife told me when she was in residency that, and like you, I mean, both of you went to the same medical school, had the same kind of training, where there was a huge emphasis on clinical training.
Absolutely.
And she had to go through 27-hour shifts. And the theory behind it was that you needed to follow a patient for at least 24 hours to see how that patient was going to develop over time. And you needed to be on site to do that. And the pendulum has sort of, it was at one point, it has now swung the opposite direction. And there needs to be, just in medicine, as in most things, some moderation. So I'm not saying that people need to be yelled at by their by the supervising physicians, and they need to be mistreated, and they need to be working these ungodly hours. I understand that, but there are values to properly preparing people for the world they're going to be entering.
Right.
And not doing that means you are putting out there people with enormous amounts of power over other people's health care, and they are ill prepared.
Right.
I mean, I'll make money from it, but that won't be good for society.
Right. Scary.
It is.
And that's why I say maybe with the influx of concierge medicine, and certainly I'm a big advocate of we need to reform graduate medical education. I think we need to talk more about physician empowerment, certainly from a business perspective that we talked about earlier. Newer physicians need to be trained on business strategies and what that looks like. So what do you think is the biggest satisfaction in being a lawyer?
To me, it's sort of, it's helping my clients achieve what their goals are. I mean, that's what I'm supposed to be doing. I'm an advocate, and I'm a very zealous one. Getting the right, just result is what it is I'm looking for. And it usually takes us a while to get there. Most of the time, we are quite successful in representing that client. The frustration comes in, as I was discussing with you earlier,
right,
of the longevity of justice in order to be able to get there. The wheels of justice do not necessarily turn
they do not
quickly.
How can clients who see this podcast reach out to you and want to utilize your services?
You can go onto our firm's website, and my email address and direct dial line are right on there. I'm associated with an enormous law firm. It's what's called an AmLaw 10 law firm, one of the 10 largest in America. We're the only law firm to be in all 50 states. So my reach is national. I have clients that I place in multiple jurisdictions, and my colleagues and partners in other states help service them. But they can reach out to me going onto that website and email me, call me, and I'm more than happy to.
Is there anything you want them to know about what sets you apart from, say, the lawyer down the hall from you?
Oh, a lot sets me apart. My training is back east, and we were trained to be very sharp, be very prepared, sort of be razor sharp. When I came out here, there's a different practice philosophy. I don't subscribe to it. And I have distinguished myself from others here because I don't adopt that philosophy. I'm interested in my clients liking me, in the insurance companies that I'm repping for, liking me. I am not interested in being the popular guy on the block with the other attorneys in town. It's great if you can be, but my job is to rep my client. And unfortunately, I think all too often, people are looking to be prom kings and queens. I am looking to get the results, and I get them much more often than others get them because I take the shots that other people don't take. And therefore I win a lot more often and get the clients see the difference. And that's why they come to me. If you want,
anyone that truly knows you can see the difference. So I will vouch for that.
There is a difference, and we have people across, in my practice, my partner and I have different personalities, and our staff, we stack the group with particular personalities to get the job that needs to get done. Sometimes it requires a heavier hand. That's me. Other times it requires a velvet glove. That's not me. So we put the people in to do the job that needs doing. And we have a breadth of personalities to be able to fit the appropriate circumstance.
Producer's given me the 5-minute warning. So just want to do some rapid firing questions here. But thank you, Adam, for your expertise. And I can only imagine what I'm being billed by the second for this podcast. So you can send me the bill later.
I will send you the bill. It will be high.
Some fun rapid firing questions here. So how long have you lived in Las Vegas?
Let's see. Been here since 2018.
Okay.
So 8 years, almost 8 years.
All right. Favorite restaurant?
Joel Robuchon.
What favorite destination that you like to travel? I think I may know this answer.
That would probably be Hawaii.
Favorite thing to do with your family?
We like to probably eating out. We avail ourselves of the panoply of restaurants.
And last question: what is your best free legal advice that you would give this physician here?
Document whatever you're doing.
Very good. Thank you so much for being out of network. I really appreciate your time and what you do for our community. So thank you, my friend.
It's my pleasure. Thank you.
Adam, thank you so much for joining us today. Your insights into medical malpractice defense, licensing board actions, and the legal realities physicians face were incredibly valuable, and we truly appreciate you taking the time to share your expertise with our audience. And as always, a special thank you to my co-host, Dr. Rishi Seth in Tampa. Your perspective and thoughtful commentary continue to elevate every conversation we have here on Out of Network. To our listeners, thank you so much for tuning in. If you found today's discussion helpful, be sure to subscribe, share the episode, and leave us a review. We'll see you next time on Out of Network.